Okay, we're going to go ahead and get started. So good afternoon, everyone. Thanks for joining today for this presentation on AI. A few housekeeping matters before we dive into the content. First off, this presentation is offered for general information purposes only, so nothing in the presentation is legal or professional advice. There's no attorney-client relationship that exists by joining today. You're advised to consult your own legal counsel on questions pertaining to this topic. This presentation may be attorney advertising under the Michigan and Illinois rules of professional conduct. Any inquiries concerning this material can be directed to myself at the address below. And the Supreme Court of Illinois does not recognize certifications of specialties in the practice of law. So thanks for joining us. I originally had this framed up as a lunch and learn. So if you're on your lunch hour and you're eating, then I guess we can continue to call it that. But in any case, this is a presentation on AI risk and compliance. And so I'll be presenting today. I'm an attorney focused on data privacy, cybersecurity law, and now artificial intelligence. And so these are three topics that are distinct disciplines, but have many intersections and overlaps in key and critical areas. And so we advise clients on these three topics, sometimes independently and sometimes together when multidisciplinary expertise is necessary. I'm also a CIPP, a US, a Certified Information Privacy Professional, if you're familiar with that certification from the IAPP. So today's topics are going to include some just brief overview on AI, sort of setting up the background of what we're talking about here, the technology that's at issue. We're going to talk about AI law and regulation. These are laws and regulations that are emerging to discreetly regulate AI independent of other subjects. So, of course, all the laws that are already on the books may apply to AI in various circumstances, depending on how it's being deployed and utilized. But we're going to cover the emerging AI law and regulations. We're also going to cover data privacy laws that apply to AI and a topic called automated decision-making, which is a topic some people may be familiar with if they're operating in the privacy space. How does that touch AI? How related are they? What are some things to think about? The topic of cybersecurity as it pertains to AI systems, right? So AI systems have unique vulnerabilities. They have a unique attack surface. There's unique types of exploits that can be leveraged against AI systems and unique harms that can result. And so we're going to talk about some of those. We're going to talk about the topic of intellectual property and how that relates to AI, right? So, how is information and protected information being used to train AI models? Are the outputs of AI systems protectable under existing intellectual property laws, et cetera? So there's lots of active litigation going on there, and I can provide some updates on stuff like that. We're going to talk about contracting around AI. So if you're entering into a contract, for example, for an off-the-shelf model that you're going to fine-tune or refine and deploy in a particular circumstance, what are some of the terms that you want to think about, at least in terms of those agreements? We're going to talk about unlawful biases, right? So obviously many different AI tools are going to be including inherent biases, but there are some that, of course, we want to try to avoid liability and running afoul of the law. And then we're also going to talk about liability. So how can AI systems give rise to legal exposure? And as you might imagine, the existing laws on the books provide plenty of avenues to bring claims for AI-related issues. So those are the broad topics we're going to cover today. There's a lot of material in each of these. Each of these could be an independent presentation. So we may just scratch the surface on some. I'm going to move fairly quickly. Of course, if you have questions, feel free to ask them at the end, or you can contact me directly. So briefly, let's just do a quick overview on AI and what are the unique characteristics of quote unquote AI systems, right? So unboxing AI, how do we distinguish AI from simple deterministic algorithms? When I say simple, I mean, that's a loaded term, right? You can have very complicated deterministic algorithms, but AI is inherently different. What are the categorical stages of AI technology sort of over time? And what are some of the common applications of AI in industry? So first, let's talk about the stages of AI technology, right? So just looking at recent history, if you consider the '80s fairly recent, which I I sort of do, we think about the past. We think about deterministic sort of algorithms, limited functions, no memory, no learning, right? So if you remember, IBM Deep Blue, the Netflix original recommendation engine, certain types of industrial automation, those types of AI systems are called reactive. They had fixed outputs, but they were advanced for their time, right? And what those gave birth to were sort of the now more complex limited memory AI systems, right? So this is the chat GPTs of the world, right? Generative AI system, right? It's different in that it's probabilistic, meaning that it does not have a fixed set of outputs, right? If you put into the formula, it doesn't always result in the same output, right? So the probabilistic nature of AI systems, the limited memory AI systems, is what makes them, in my opinion, much different than past technologies. They still have narrow functions. Often they have limited memory. They can be subject to reinforcement learning, which is a significant difference over reactive AI. And of course, these examples include large language models, stable diffusion technologies, autonomous vehicle systems, and even AI assistants, like you see Copilot and the like, right? And so this variable output is what makes them very much unique. What is the future, right? So artificial general intelligence is what's on the minds of all the leading researchers in the AI space. And what they're trying to do is basically simulate generalized human cognition, but at perhaps an even more advanced level. It has broad functionality. It can infer and anticipate emotions, and it may assume human type roles and responsibilities. So that's really what what's on the near term horizon for the AI developers. And then obviously what's theoretical is, the stuff of theoretically science fiction, right? Or basically self-aware AI, considered super AI. It's self-aware, it knows that it wants and needs, and it, formulates own thoughts, feelings, emotions, and beliefs. So that's, obviously the stuff of, at this point, sort of science fiction, Hollywood, etc. But, who knows where this technology will go. For our purposes today, we're going to focus on basically what is the present, the limited memory AI systems that are proliferating so rapidly. So just to highlight or explain this maybe in a little bit in an illustrative example, right? I came up with this example of dueling chatbots, right? So on the right, you have your traditional rules-based chatbot. This is basically an algorithm that says, if then else, right? So it's basically programmed that if you put in one input, it's going to give you the same output every time, right? So yes, it may have a large decision tree that it follows, and it can be complex, and of course, it itself can produce undesirable results. It is finite. It is very much fixed and non-variable in its outputs, right? On the left is a more advanced AI chatbot, which is probabilistic. So take, for example, an AI assistant that is, like a large language model. It's going to make predictions about what to say or output based not necessarily on strict programming or if then else statements. It's going to be dynamic based on continuous learning, and the predictability is quote unquote managed. So it's something that we don't know whether the same input is always going to result in the same output. And that variability, of course, makes it unique and also gives rise to risk, right? Because it's a lot harder to weed out unexpected and undesired outputs than it is from a simplistic or more simplistic rules-based system. So what are some common AI applications, right? So obviously there's many more than what I have listed here. These are sort of being used in various spaces, right? Predictive analysis. And you can obviously see the value of that in healthcare. You can see it in finance. You can see it in employment, recruiting, and hiring. You can see it in education context, recommendation engines, right? So, learning preferences, improving outputs and results. You see that on, like I said, Netflix. You go on and it's making suggestions to you about what you may or may not like. You of course have generative AI tools. Those are for creative works, helping to compose written works or even images or illustrations or art. Entertainment, you see that, AI being deployed in video game in the form of bots, augmented reality applications. You see AI being used in risk assessment and compliance, right? So can an AI system more quickly evaluate or assess risk in a particular system, can look for compliance gaps faster than a human assessor? Task and process automation, right? So obviously automating manual tasks that may have taken a team of people, making things move faster. AI assistants, chatbots, digital companions, we've talked about those. Surveillance, identification, and monitoring, obviously controversial, right? Biometric surveillance systems being able to capture images of an individual and relate that data and re-identify that person in different places and contexts and time periods and associate that information together to build a profile. Autonomous vehicles, right? We see a lot of experimentation going on with those. Waymo, if you're familiar, Google startup around AVs. And of course, military and defense. This technology is going to be used in all sorts of military and defense contexts. So, and there's of course others, as I've mentioned. So law and regulation. So as this technology has proliferated, new laws and regs have come on the scene to help, right, control, regulate, sort of seam in what's possible in some circumstances, and at a minimum, provide some guardrails around AI technologies. So we're going to talk about some of those. There's some that are not in the deck that I'm going to speak to just briefly because they're so fresh and fluid that they're happening now. But basically, as I mentioned at the outset, right, there are really two bodies of law here, right? There are these laws and regulations that are discrete to AI. So a perfect example of that is the EU AI Act, recently put into law in the European Union. And then there are laws and regulations that regulate AI collaterally, right? So these are laws that whose focus is on a separate and distinct topic, but somehow are adjacent to AI or capture AI or the consequences of AI in some way. So the California Consumer Privacy Act, or CCPA, is one of those laws which regulates automated decision-making, which of course can be related to AI and therefore regulating AI, right? So, there's a broad spectrum of laws that can apply in any given context, and these can also include sectoral laws and regulations, right? So, obviously, especially in the US, a lot of our legal landscape is carved up into sectoral laws, right? So healthcare obviously is regulated by certain regulatory authorities. There are certain regulations that apply to healthcare entities, and those may be regulated. AI within those contexts may be regulated sectorally. Same with finance and same with other areas as well. So just to give you a brief list of some of the current discrete laws and regulations that are out there, right? The New York City Local Law 144 of 2021 is now in force. And that law is concerned around bias in the hiring process, right? So as you receive applicants, if you're using automated tools to screen them, to sort them, et cetera, right? This local law applicable to New York City only is concerned about evaluating those applicants and for bias. The Utah Artificial Intelligence Policy Act, which is now in force as well, it's very limited in its scope. It really deals with disclosure around the use of chatbots and AI type technologies. And then we have the new Colorado law, right? It's enacted, doesn't go into force into 2026. We're already hearing some rumblings that there may be some major amendments to that or walkbacks because there's pushback by industry. But it's a very comprehensive law. So Colorado is really the sentinel jurisdiction in the US to address AI from a fairly holistic perspective. The EU Artificial Intelligence Act is probably similar in its sentinel status, but on the global stage, right? The entire world is looking to that particular law for how to frame up and organize regulations and laws in their jurisdictions. Canada is toying with some proposals too, as well as South Korea, and many other jurisdictions are studying AI and trying to figure out how to regulate it, how to address it. And usually there's competing interests, right? One is they want to protect the public in some sense, and they want to also not completely hamper developers and the sort of progression of the technology. So those are the two big interests in play in the legislative process. Some other notable AI guidelines and pronouncements, if you're interested in this space, these are really good reads, right? The UNESCO recommendation on ethics of artificial intelligence gets in sort of the ethical side of things. You see some of those concepts fleshed out in some of the laws, so something to take a look at. the OECD or the OECD AI principles. That's the Office of Economic Cooperation and Development. And then there's a U.S. presidential executive order on the safe, secure, and trustworthy development and use of artificial intelligence. It's from the current administration, Biden administration published that. And then there's a bunch of NIST publications as well on various aspects of AI. Probably one of the most useful is the NIST Mitigating AI and Machine Learning Bias in Context document. Very helpful if you're in the weeds on this space. So just to dig into these quickly, right? The New York City Local Law 144 prohibits employers and employment agencies from using an automated employment decision tool in New York City unless they ensure that a bias audit was done and they provide required notices, right? So that notice part says, hey, if you're going to use this tool, you got to provide those applicants notice that we're using this type of tool. And an AEDT in this context is a tool that uses machine learning, statistical modeling, data analytics, or artificial intelligence to help employers and employment agencies make employment decisions and substantially assist or replaces discretionary decision-making. So this is something that you see common in many of these laws around automated decision-making or AI. Many of them are less rigorous if there is a human in the loop, right? So if there's an AI tool or an automated decision-making tool that's in play, but there's still human level review of the results, then usually the requirements are softened as they apply. But the AEDT bias audits must be performed by an independent auditor and results must be publicly published. And I'm going to show you some examples of those in just a moment. So basically what this law requires is that you calculate the selection rate for each category, right, of candidates, right, based on certain factors. And then you calculate an impact ratio for each category. And then you have to ensure that the calculations separately calculate the impact on sex categories, basically male versus female candidates, and on race and ethnicity, and then as well as intersectional categories of sex, ethnicity, and race, right? So that gives you a broad view of whether or not the automated tool that you're using is disproportionately, right, scoring or ranking candidates that are of those particular categories, right? And now, while this law does not require you to necessarily do anything with that particular information or take any specific action, it might be an indication that your AI tool has a bias that you perhaps don't want, right? And for example, like if you're in an industry or you're a contractor that has specific requirements around these topics, that might be an indicator that you're not in compliance. So, it's a fairly simple, computational task and formula to prepare the bias audit, but it will start to show you some results. So here is just an example, right? You can start to see the data here, the number of selected and the selection rate being 48%. So your impact ratio is 1 because that's the highest, and then female candidates. So, your impact ratio here is not all that different, right? It's pretty comparable. There's some selection rate bias towards males, but it's not dramatic. Same thing here. You can see the same type of breakdown done on the basis of race and ethnicity. And you can see here as you go down, right, that the impact ratio is higher. So, right, there's obviously biases towards certain ethnicities, while others, I should say there's biases in favor of certain ethnicities, while not so much in favor of others. And so that's kind of the results you can expect from running that and the information that it provides. And here's a intersectional categories view of that as well. So you can see how we've now added additional variables to the table, and you can see how, right, the selection rate is highest for non-Hispanic, Latino, male, white candidates, right? So based on this data. So that just shows you what that law requires. And again, it doesn't require you to do anything with that information other than to observe it and provide notice to candidates. So the Utah Artificial Intelligence Policy Act, I mentioned this one. It's very simplistic in essence, but basically requires disclosure when a user is interacting with a generative artificial intelligence system. That's one that's trained on data, interacts with a person using text, audio, or visual communication. and generates non-scripted outputs similar to outputs created by a human with limited or no human oversight. Again, there's that human oversight component, right? So, basically, if you're designing a chatbot and you're going to have it interacting with humans, basically, we need to disclose this is a chatbot, it's an AI system, it's not a real human, right? And so basically, it's a way of creating transparency around the use of the AI tool so that people are not confused or misled. All right, so to the Colorado law. Again, as I mentioned, this is the first significant US law to regulate AI systems. It applies principally to high-risk AI systems, HAIS. It sets forth requirements for both developers and deployers, which are defined terms in the statute. There's no threshold for compliance, but there are reduced requirements for small and medium-sized businesses, which are defined in the statute. There is a safe harbor, a rebuttable presumption if you're in compliance with the law, meaning that, if you're doing everything you're supposed to do, it's going to kind of shield you from, as a sort of prima facie way from liability. It's enforced by the Colorado Attorney General, and the civil penalties can be up to $50,000 per violation. So what is an artificial intelligence system under this Colorado law? They define it, and it's interesting to look at the definitions of AI systems, et cetera, across jurisdictions, because, different jurisdictional, tendencies, biases, cultures, et cetera, legal formulations play into how they define it. But the Colorado one is pretty consistent with the EU definition, as well as that's been adopted by NIST. So it's any machine-based system, right? So machine-based system that, for any explicit or implicit objective, infers from the inputs the system receives how to generate outputs, including content, decisions, predictions, or recommendations that can influence physical or virtual environments, right? So there's quite a bit there. It's got quite a number of elements baked into it, but basically, it is distinguishing itself from basic algorithms like we talked about in the beginning of the deck, right? So this is a system that is inferring from inputs, right, how to generate outputs. That means that there's a model that's been trained that's going to produce variable outputs, most likely, right? And then obviously those outputs can be content, decisions, predictions, or recommendations. That's a pretty broad range of outputs, and that they can influence physical or virtual environments, right? So that's pretty broad as well. So I think that this is going to capture most of the types of systems that people would consider AI systems, right? So what's a high-risk system according to this, the Colorado law? Basically, it's a system that makes or is a substantial factor in making a consequential decision. So to determine whether or not, the Colorado law is going to apply to an AI system that you're working with, the question will be, not only is it a quote unquote artificial intelligence system as defined, but is it making, or is it a substantial factor in making a consequential decision, which is a decision that has a material, legal, or similarly significant effect on the provision or denial to any Colorado resident of, or the cost or terms of, an educational enrollment or educational opportunity, employment or employment opportunity, financial or lending service, an essential government service, healthcare service, housing, insurance, or a legal service, right? So that is a very explicit list of things. If your AI system is operating outside of making those types of decisions, then it's not going to be covered by the Colorado law. What's interesting is that there are many decisions that AI systems are making on topics that are very much close to or adjacent to these topics. So the question is like, are you using it in a recruiting process, right? Does that fall within, right, an employment or employment opportunity decision? That's a tough question, and that's where lawyers are going to have to come in and weigh in on that and help interpret case law that will eventually emerge from lawsuits around these laws. So what are the requirements for developers? So under the Colorado law, developers must maintain a duty of care to avoid algorithmic discrimination. They must maintain documentation. There's a litany of things here that they must do. They have to perform an impact assessment. They have to have a website statement that is clear and readily available, contains information about the high-risk AI system, how it was developed, how it's managed, foreseeable risks of discrimination, et cetera. And they have to provide notification and information to the Attorney General on request. So, quite a bit of stuff to do here. This is a summary, right? If you actually dig deep into this, there's a lot going on there. And so if you're really working in this space, I would commend that to you. On the other hand, right, deployers, right, they also, so there's someone who is acquiring a developed AI system. They also have a duty of care to protect consumers from algorithmic discrimination. They have to maintain a risk management policy and program. They also have to complete an impact assessment for the deployed high-risk system annually and within 90 days after any intentional or substantial modification. They have to provide transparency, and there's several obligations subsumed within that obligation, which is a pre-deployment notice, adverse consequential decision notice, a website statement, and a generative AI notice, if applicable. And then also, they must communicate with the AG and notify the AG if they believe that there has been algorithmic discrimination caused by the system. So let's jump across the pond and talk about the EU Artificial Intelligence Act. So this is a classification-based regulation. So, the Colorado law you just saw identified high-risk systems by very specifically identifying types of consequential decisions that would be required, that would require compliance. Under the EU Artificial Intelligence Act, they approached it similarly, but it's a little bit more risk-based and it's a little bit more top-down. I think there's pros and cons to both approaches. Obviously, you've got governments in both of these locales that are trying to come up with the most appropriate and sort of sustainable, if you will, regulatory framework. It's difficult because AI technology is fast moving. It's very fluid. So you're basically trying to capture something at a point in time and say, this is how we want to regulate it. But in any case, the EU AI Act really focuses on prohibited risk, high risk, general purpose AI, and non-high risk systems. And depending on which classification your AI system falls into, the regulations are commensurate with that type of classification. So the EU AI Act is going to apply primarily to system providers and deployers similar to developers and deployers under Colorado, but it also includes AI system importers, distributors, and manufacturers. So the EU AI Act uniquely defines those terms, whereas the Colorado law does not. Interestingly enough, if you're familiar with the General Data Protection Regulation in the EU, this EU AI Act also applies, quote unquote, extraterritorially to providers and deployers where the AI system output is used in the EU, right? So for example, you're a US-based company, you're targeting the US market. Even though you don't have a physical presence in the EU or boots on the ground working there, the fact that if you're targeting them and your AI system is going to be applicable to individuals inside the European Union, then the EU AI Act will apply to you extraterritorially through international treaties. So how does the EU define an AI system? Well, it defines it as a machine-based system designed to operate with varying levels of autonomy and that may exhibit adaptiveness after deployment, and that for explicit or implicit objectives infers from the input it receives how to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. So there are some common elements here with the Colorado law. I would say that the EU definition is a little bit broader. It's a little bit more generous in terms of what it would scoop up in terms of the sort of machine-based system that it's going to capture. But, that will all be sorted out over time. So moving through these EU AI classifications, we'll start with prohibitive AI applications. I don't want to spend too much time on this because we'll get really into the weeds. But prohibited systems, meaning these are not permitted without sort of special circumstances applying, would be anything involving behavioral manipulation or subliminal techniques to cause significant harm, exploiting the vulnerabilities of a person's age, disability, or specific social economic situation, biometric categorization to deduce or infer race, political opinion, trade union membership, religious or philosophical beliefs, sex life, or sexual orientation, evaluating or classification based on social behavior, personality characteristics for the purposes of a quote unquote social credit score, obviously a controversial topic, real-time remote biometric identification in public spaces, and then risk assessments of natural persons in order to assess or predict the risk of their committing a criminal offense. There are exceptions to that for law enforcement purposes as well. High-risk AI applications. So these are ones now that are heavily regulated but permitted, right? So AI systems that involve biometrics, critical infrastructure, education and vocational training, employment, law enforcement, migration, asylum and border control management, administration of justice, profiling of natural persons, and risk of harm to health and safety, or an adverse impact on fundamental rights. So, and then they've also got the circumstances otherwise regulated by EU law. They've given themselves the ability to augment this list, supplement it with additional topics that may come up over time. So what are the requirements for high-risk systems? This is a gross simplification, right? It's establishing a risk management system through the AI system's lifecycle, data governance, training, validation, and testing. That's TAV. You'll see that in the NIST documentation as well. Maintaining technical and compliance documentation for assessment by authorities, designing the systems to keep records, for example, logs necessary to automatically record events relevant to identifying risks and substantial mods, providing instructions on the use by developers, allowing for effective human oversight and ensuring accuracy, robustness, and cybersecurity, and establishing quality management systems to ensure compliance. A lot of stuff going on there. Again, this is a gross simplification for high-risk systems. Non-high-risk systems still have obligations, basically ensuring, I sum this up as having AI literacy of their staff and persons dealing, and maintaining defensible assessments, records, and testing documentation to respond to regulatory challenges and inquiries. That's really what you need to be focused on if you're outside of the high-risk systems defined by the EU AI Act. For general purpose AI, right? General purpose AI is like AI that is intended to do basically anything, right? So you might think of large language models like ChatGPT or others, Google Gemini, Grok, and the like, as being sort of general purpose AI. They have specific requirements of maintaining technical documentation, including training and testing process and evaluation of results, maintaining information and documentation to supply to deployers that intend to integrate that GPAI model into their own AI systems, establishing policies to comply with EU copyright directive, and publishing a sufficiently detailed summary of the content used for training the model. Just to summarize here, the key takeaways are that there are emerging laws and regs that are going to increasingly directly regulate AI system providers and deployers. Some of them are going to apply extraterritorially, meaning they've got global reach. High-risk systems are going to require extensive compliance efforts to meet the requirements. Penalties for noncompliance, for example, under the EU AI Act, may reach 7% of global turnover. That's a very high, obviously, a penalty to face for noncompliance, especially for a large multinational company or for a scaling up startup that's really sensitive to that type of stuff. Multidisciplinary teams are going to be needed to collaborate on compliance, governance, policy, documentation, reporting, right? There are so many different subspecialties involved in governing AI and managing them that there's going to need to be a team of capable professionals working on it. And then AI system providers and deployers should plan ahead, right? So if you're in the process of building a system now, or you're going to deploy an off-the-shelf system that you're procuring from someone else, you need to be thinking about these requirements, because the last thing you want to do is have to go in and reverse engineer or re-engineer something that's already in production. Data privacy. So this topic, right, has a great intersection with AI when personal data is involved. So privacy and data protection laws like GDPR and CCPA regulate the processing of personal data. These laws are on the books. GDPR from 2018, CCPA from 2020. Personal data cannot lawfully be used or processed without compliance. Under GDPR, data controller must have a lawful basis before processing personal data. Automated decision-making and profiling are specifically regulated, right? So that's some of the linkages to AI. It's the connective tissue there. High-risk processing may require data protection impact assessments. Privacy rights apply to personal data processed by AI systems, including the right to opt out and or object to the processing. Consent and transparency requirements may apply to automated decision-making, meaning you may have to allow people to withdraw their consent to the use of your AI system if that system is used to process their personal information And for example, that the output of the AI system is consequential. And that's already existing under the privacy laws that are on the books. So I wanted to talk briefly about how the CCPA, which is a privacy law, right, is going to deal with AI and topics surrounding AI. So the CCPA has a draft regulation. It's still being prepared or drafted or circulated for feedback by the California Consumer Privacy Agency, the CPPA. But the automated decision-making terminology in the CCPA has basically been leveraged by the regulatory authority to promulgate rules across AI where it concerns personal data. And so you can see them stretching sort of the purview of what one might have thought was sort of the limits of what they could enforce to now include AI, which is extremely interesting. We'll see if it survives challenge. But basically, they're going to cover everything from software processes, machine learning statistics, or other data processing, or AI that processes personal data to execute a decision or facilitate human decision making. So it's this facilitate human decision making component too is even a broader. If you recall earlier parts of this presentation where we talk about if there's a human in the loop, usually the requirements are relaxed. They're not taking that approach. They're saying even if it's used to facilitate human decision making, we're going to have the ability to regulate this. So what are some of the requirements in the draft regulation under the CCPA? Specific notice, and this notice is quite detailed, right? You need to provide the purpose of the automated decision-making, the quote-unquote logic used, right? So this is the logic, the computational logic used in the automated decision-making technology, including the key parameters that affect the output of the automated decision-making, the intended output of the technology, for example, a numerical score of compatibility, how the business plans to use the output to make a decision, including the role of any human involvement, and whether the business's use of the automated decision-making technology has been evaluated for validity, reliability, and fairness, right? So that's sort of that TEV framework that we talked about before. Mechanisms to opt out and other rights of the consumer, risk assessment, which is suggested in the draft, and information upon request by consumers about the outputs, right? So data, consumer or data subject rights, privacy rights, making those requests and demanding information about the processing. So the key takeaways here are that privacy laws are going to apply to personal data processed by AI systems during training and in production, right? So are you using personal data to train AI models? That's going to be governed by existing privacy laws, and using personal data to train AI models without consent or some other lawful basis is a big no-no. That's going to get you in trouble, right? Training data should be de-identified or anonymized before being used to train the systems. So for example, using dummy data, synthetic data, de-identified data, or other types of information. We have a lot of strategies that we've developed for clients on this topic. So if you're in that process of, hey, what data can we use to train this model? We've got a lot of good advice for you on that topic. AI systems should be designed to not ingest personal data unless absolutely necessary to perform their purpose. Employees who may use AI systems in the scope of their employment should follow company policies on the use of AI, which should prescribe permissible and non-permissible uses. For example, employees may not share personal confidential information with AI systems, right? So there's good reasons for that. There might be exceptions, but they need to be fleshed out. And then privacy laws may impose specific obligations related to automated decision-making. So as I mentioned, CCPA, GDPR, and a whole host of other global privacy laws already address that topic and are regulating it today. Let's talk briefly about cybersecurity. So at the outset, I mentioned that AI systems have unique vulnerabilities and require their own defensive strategies to prevent cyber attacks and other cyber-related risks. So what are some of the security risks to AI systems? Well, they're vulnerable to the same types of cyber threats as other computing systems, right? SQL injection and buffer overflow attacks, right? Those are typical, common, well understood in the cybersecurity community, but they also have unique vulnerabilities. So internal and external threat actors can compromise the confidentiality, integrity, and availability of AI systems, right? So anybody familiar with the security, CIA, or confidentiality, integrity, availability, right? Those are pretty well-known terms. NIST has indicated that occurrences of AI system compromises have already occurred, right? So for example, system poisoning, right, in the training stage could cause significant damage to not only the AI system, but can also produce undesired and unanticipated outputs, right? Damages and losses resulting from cyber attacks can be significant. So NIST, and I should have defined this earlier, the NIST, if you're unfamiliar, is the National Institute of Standards and Technology. It's a U.S. Organization and of the federal government. And basically it promulgates a lot of special publications on unique topics. One of them happens to be information security, cybersecurity. Well, they've also now included these presentations on AI. And so in this NIST publication, they highlight 4 unique attacks, right? Evasion attacks, poisoning attacks, privacy attacks, and abuse attacks. I don't want to get into the details of each of them because it'll take us a long time to really work through them, but you can see them here and you can look up this documentation and review it for yourself. But if you're building or deploying an AI system, you need to be thinking about how are we going to protect that system, not only from the traditional types of cyber-related threats, but also these unique attacks against AI. NIST has also published a taxonomy of generative AI attacks. These are unique to generative AI systems. You can look at these diagrams. They sort of show you where these attacks occur relative to the type of the attack and what is what's being compromised. So if it's availability that's being compromised, there's various types of attacks. Same thing with privacy, same thing with integrity and abuse. So this is a lot of work has gone into this, and for security researchers, anybody involved in either doing security pen testing of AI systems and the like, understanding this taxonomy and this basic framework is going to be highly beneficial to advising the client. Just to provide you a very simplistic evasion attack of an AI system, this is a self-driving vehicle, right? It's going down the road. The AI system is reading the information that it's picking up through LiDAR or whatever various system it's using. And somebody comes and puts some deceptive markings down, right? So the AI system can be fooled, right? So this it's considered an evasion attack. And of course, I mean, it can cost a human life. So while it's not a sophisticated attack in terms of its technical nature, it is nonetheless harmful and also relatively easy to deploy. So, folks that are involved in AI need to be thinking about security and risk throughout the entire development process. So there's some AI cyber adjacent issues that I just wanted to bring up because they're very interesting. AI can obviously be used for offense in the cyber landscape, right? So they can be used to discover vulnerabilities, enhance social engineering attacks. That's, of course, email phishing. An AI system can compose phishing emails. It can learn information about the recipient. It can tailor emails. It can respond in an intelligent way to help trick someone, right? It can also operate botnets, help guess passwords, compose malware, which is already being done. And it can also be used in a defensive capacity, right? So AI can be used to interpret threat intelligence, monitor networks, and intercede faster than a human SOC team, right? A security operations center team. So that's already being done. Deep fakes, of course, people are now familiar with those. Most people are familiar with basically somebody creating basically a false or fraudulent image, video, etc., emulating or simulating someone else. They can be used for deception, manipulation, and to commit fraud. Voice recognition, right? So someone can record a very small sample of your voice, and they can use that to fool people to do social engineering, to hack into your accounts that use voice recognition, authentication methods, and the like. So there's a lot going on there. And AI can certainly interfere with and unduly influence public opinion, right? The political processes. There's an AI elections accord with 7 goals, detecting deceptive AI content, right? We're going to see that play out continuously over time, unfortunately. So here's some key takeaways. I want to try to stay on time, so I'm going to just kind of skip talking about these. I think we covered them at depth in the previous slides, but you can just briefly review these here. I think the biggest one for me is that the bottom, that security breaches of AI systems can lead to significant legal and regulatory exposure and reputational damage. And that's why we're worried about security risk with respect to AI systems. It should not be an afterthought. Security should not be bolted on. It needs to be thought of holistically at the inception or the origin of the plan to build or deploy the AI and be used accordingly. Intellectual property. So this is a big topic, right? You've seen a lot of celebrities, Sarah Silverman, Scarlett Johansson, I believe others filing lawsuits. You also see big companies, the New York Times filing lawsuits against OpenAI, which is the creator of ChatGPT, and its parent company, or quote unquote parent or adjacent company, Microsoft, for violating copyright laws. So there's a whole lot going on here. And again, this section could be its own presentation. But in general, we're worried about third-party IP rights. So AI systems, especially generative AI systems that produce content based on information they've been trained on, may infringe third-party IP rights. That infringement may occur during the training itself. Does it qualify as fair use to take someone's written work, which is copyright protected, and use it to train an AI system to produce similar outputs? That's an open question. Training data, whether it's written, creative works, images, computer code, they're all subject to copyright, right? So even doing things like web scraping, right? So AI systems, the development of an AI model, or even fine tuning a model, right, based on additional input data, there's a huge appetite for data, right? So all the ways that AI developers can get data is being utilized, including web scraping, right? They're going across the web, scraping information from reliable sources that they think is high quality content that they're going to pump into their AI model to improve and enhance it. You need to be thinking about, are we interfering with third-party IP rights, and are we violating terms of service provisions? The answer may be yes, and there is risk associated with that, legal risk, of course. Likewise, the outputs of generative AI systems can also give rise to claims of IP infringement by the authors whose work the output resembles. This resembles word here is my word, it's not a legal word. There are cases where courts are finding in favor of the AI developers where the output is not an exact copy, but it simply resembles the original work, okay? It's a subjective test in terms of whether or not an infringement has occurred. And so certainly if the AI output is an exact copy and it's a substantive, selection from a larger publication, you're probably going to be more likely to be found in violation. If it is content that is derived or a derivative and it just has, comparable types of thoughts, ideas, or information, less likely to be infringement of copyright law. So here's a list of some infringement claims that have been brought. You can look into these. Sarah Silverman's case, some of it's been thrown out, some of it's still proceeding. Getty Images, if you're familiar with Getty Images Online, right? They sued Stability AI for the use of millions of images to train their AI models to produce stable diffusion or AI generated images. So there's lots of litigation going on here, and it needs to be followed. Eventually, there's going to be some resolution to this. Right now, these cases are claiming tens of billions of dollars in damage. The New York Times is basically saying, look, like the damages are so much, it's almost hard to put a number on it because you've used so much of our editorial and journalistic content to train models to produce content that looks like or mirrors our written work. On the flip side, can we protect AI outputs? This is a super interesting topic because it says, okay, you are using an AI system, you're a creator, and let's say you're going to create a new comic book. We'll take this case of Zaraya of the Dawn, right? So you have this artist who's using an AI system to generate AI images based on the prompts that the artist is entering into the AI system, right? So there's a lot of creativity that goes into creating the prompt and learning how the AI system will interpret that information to produce the output. Well, the USPTO said, sorry, but this does not constitute a patentable invention because the inventorship status cannot be assigned to an AI system. It has to be assigned solely to a human. So this has significant implications because you can imagine many companies are going to attempt to use AI systems to help speed up their R&D, to help improve their inventive process, right, in the formulation of new engineering models, pharmaceutical products, you name it, AI systems are going to be involved in that development process. So what will be the line in terms of how much influence that AI system can have over the output to the extent that it's not patentable? Because certainly if you're developing a new product and you can't patent that product because an AI system contributed too much to sort of the creative spark that gave rise to the invention, that's going to be a big problem for you when you go to take that product to market and you want exclusive protection in the marketplace. So some key takeaways here about IP. You need to think about both the use of third-party IP in training and in the outputs of AI systems, whether there's any violations there. And you need to think about whether you're using AI systems to produce sort of the fruits of the inventive process, whether or not you'll be able to protect that output. AI contracts. So this topic really concerns negotiating terms around AI products and services. Many companies are not building their own in-house AI systems. They're buying them off the shelf, they're licensing them, et cetera, because it's much easier to do that. It's an easier entry into the space. So general purpose AI systems like LLMs, ChatGPT offer cost-effective, off-the-shelf, pre-trained solutions, but they may represent a black box in terms of their underlying data model. So, right, we just talked about all the risks associated with the training of an AI model, right? If you buy something off the shelf, you are not going to be entitled to see what's inside the box that they use to train that base model. Just because you fine-tune that model does not mean it's suitable for performing a particular task, right? So using a general model, you don't know what's in it. There's risk there associated with the IP that it outputs, and there's risk associated with the model itself not being suitable for the task that you have it performing. Procuring AI products and services, including data, exposes the deployer of the AI system to unique risks which must be addressed in the contract, if possible. If you're a small operator or a small deployer, you're probably not going to be able to get a developer to agree to many of these contracting points I'm about to give you. But the types of things that in an ideal world I would advocate for representing, for example, a deployer who's procuring an AI product or service, I want reps and warranties regarding data provenance, including in relation to personal data, third-party IP, and information subject to secondary use and restrictive covenants. I want indemnifications around IP infringement in relation to the data, the model, and any applicable software, and any other inventions that are associated with it. We want rights to information ingested by the AI during its use. Does the vendor have the right to use the information obtained from the end users to train the AI? We want audit rights, if possible, in relation to the data and the model. We want commitments in relation to the applicable legal and regulatory requirements. We want appropriate service level agreements and product support for that service or product. We want to appropriately allocate risk through disclaimers and limitations of liability, indemnification. And we want data protection and security addendums where they apply. So those are the top things. Unlawful biases. So, of course, we want to eliminate unlawful biases from AI systems, right? Unlawful bias is something that would be unlawful discrimination based on a protected class, right? Race, color, religion, sex, national origin, age, disability, and genetic information are almost always going to be prohibited. Likewise for pregnancy status and sexual orientation in many jurisdictions. Biases in AI systems are a major risk, and subtle biases can be difficult to detect and root out. It should be notable that if your training data is biased, right, if your labeling process during the development of the AI system has a small amount of bias, and the system continues to relearn that, there can be a multiplier factor that expands the amount of bias that you actually started with over a period of time. So bias can be introduced in AI systems in various ways. It can be introduced in the training data, right? If the source data, again, includes bias, it's almost certain that the corresponding bias will be reflected in the outputs unless it's corrected. The labeling standards are extremely important. The design of the model, including how weights are assigned to particular associations and other design factors, can affect bias, as well as prompt injection. So Google had a little bit of an embarrassing moment when it first sort of launched Gemini. It attempted to modify AI outputs through filters and other methods on the prompt side to produce a certain effect, but it had unintended results that were, sort of highlighted and brought embarrassment to Google. Because of relearning, bias in an AI model can become more pronounced over time due to reinforcement. It's often referred to as bias amplification. It's a term you should be familiar with. AI applications at risk for bias. So any type of system that can produce unlawful bias will be at the greatest risk. So I like to think about bias in employment and selection related screening and ranking, right? Because that's where you already have a large base of laws and expectations around bias in the employment context, credit and loan qualification and pricing, insurance underwriting, healthcare and resource allocation, housing searches and selections, right? You think about redlining. Are we unintendedly redlining someone because there's bias in a housing recommendation engine or something to that effect? Believe it or not, in dating and matchmaking apps, this can result as well as in certain types of advertising. The EEOC, or the Equal Employment Opportunity Commission, recently settled a disparate impact claim for age discrimination against iTutor Group, which should use an AI system in its hiring process that unlawfully discriminated against older candidates. So regulators are already out enforcing this, and I can tell you plaintiffs' attorneys will be on the lookout to enforce this as well. And when they find it in an AI system that's being applied broadly, you can imagine that if you're a large organization, and let's say you're using it in an employment or hiring related context, they're not only going to have one plaintiff who brought the initial complaint, they're probably going to have an entire class of plaintiffs who went through the same process with the same AI selection process in place, who were all affected by that. Because it's not like you're talking about one human reviewer that made one mistake. You're talking about a systemic problem that is now widespread. So what are some guidelines for preventing bias? In the employment context, the EEOC has issued guidance on what to consider. And I just want to pause for just a moment. I realize we're almost at the 1 hour mark. I've got a bit more to go. Obviously, if you need to drop, I understand it. I appreciate you sticking with us. I will publish the recording on our website and our YouTube page sometime later this week. You can find it there if you can't stick around. If you can stick around, I imagine we'll be done in about 10 to 15 minutes. So thank you for your patience as I work through this content with you. So the EEOC has issued guidance on what to consider in preventing bias in AI and algorithmic screening. The big takeaway here is that they have a 4/5 rule that states that one selector rate is if one selector rate is substantially different than another, if its ratio is less than 4/5 or 80%, then you probably do not have a bias problem. But if it's greater than that, then you certainly do have a bias problem, right? So the FTC has also published an algorithmic bias playbook to help AI operators define, measure, and mitigate racial bias in live algorithms, something to take a look at. NIST has published practical guidance on steps to mitigate AI and machine learning bias in context. Other industry associations have published sector-specific guidance, and watch out for disparate impacts to protected classes. Liability. So, of course, AI systems, just like anything else, are going to be subject to legal liability. The way that legal liability can come about can be through negligence and other torts, as well as breach of contract, breach of warranty, and the like. So we're going to touch on some of those here. These are some interesting and fascinating topics that I think from the legal side are going to get really a lot of attention in the next couple of years as lawsuits start to emerge around these AI systems. So AI system outputs may impact people, property, and other legal interest, sometimes in very profound ways, right? You need to assess that risk, right? Impact times likelihood equals risk is the most basic risk assessment you can do. So what is the impact? Rank it from 1 to 5. What is the likelihood that that's going to occur? Rank that from 1 to 5, multiply that. That gives you a qualitative sense of what the risk may be on a relative scale to certain identified interests, right? So you can come up with your own scales. You can come up with your own risk formulation, but that's a basic one to start with. My opinion is that trial courts and juries are almost always going to hold AI systems involving consequential matters to a higher standard than they would those involving trivial matters or matters involving humans, right? So this is borne out in some of the litigation that's concerned autonomous vehicles that have resulted in damages or fatalities. Juries and judges are human beings. They are going to be, in general, more sympathetic to a driver who accidentally did something or unintentionally got into an accident and caused harm than they are a machine that was designed to perform a specific task and do so safely and failed, right? So, it's just an inherent bias. As humans, I think that so long as our legal system is still at the mercy of the opinions of human beings, we're going to hold machines to a higher standard than we do humans. That's just as a starter. When it comes to the types of matters, right, I think that risk matters a lot, right? So an AI system that's responsible for diagnosing diseases, for example, this is a hypothetical, right? The consequences of that system failing, having a poor output, poor accuracy, a high tolerance of variables, the consequence is life and death. And so that system is going to be expected to operate at a tighter tolerance than a system that recommends TV programs, right? Or, for example, an AI system that says, we think based on pattern recognition that your favorite color is blue and you'll like blue colored shirts, or whatever the case may be. So it's really important to think about, what is the AI system doing? If it has a significant impact on people, and the likelihood that something bad will happen is high, risk is high, and you need to pay that much more attention, right? Things like low confidence intervals, high error rates, AI hallucinations, those are all issues that are going to lead to an allegation that the AI system is being negligent or defective, right? It's defective in its design, it's defective in its performance, it's breaching basic implied warranties. All sorts of claims are going to come out of the law if you have those types of characteristics. Of course, someone who's aggrieved is going to file suit. They're going to attribute to the AI system, and they're going to bring a suit. And plaintiffs' lawyers are going to see opportunity here as well. Excuse me. So in any case, right, plaintiffs can bring any types of claims, torts, including negligence, where lack of reasonable care caused the plaintiff's harm, right? The legal elements here are duty, breach, causation, and damages. Breach of warranty claims, breach of contract claims, where there's a contractual obligation of the plaintiff, right? There's a one-to-one relationship where there's privity of contract, and then statutory claims under existing laws that have a private right of action. Sometimes the statutory damages are pled damages. So how do you mitigate that legal risk that we just talked about, right? I think it's following best practices. I think it's saying we have done everything possible to remove or mitigate these risks, and we've tested, we've evaluated, we've verified and validated TEV, consistent with generally accepted standards, that our AI system was appropriate and performing expectedly for its intended task. It has to be defensible. And a good lawyer is going to help you craft that defensible posture with respect to your AI system, right? So you've got this multidisciplinary approach. You're looking at the AI system, you're evaluating risk, you're conducting risk assessments, you're maintaining documentation, you've got all of your compliance with existing discrete AI laws and regulations in place, you're complying with the adjacent or collateral laws that apply to your particular system, and you're doing everything on the industry standard side, including testing, evaluating, verifying, and validating the system to industry standards. And you can demonstrate that your AI outputs are acceptable, they're reasonable, your system is not negligent. If you get called out and you can't demonstrate any of that, you're in a very bad spot, because you will not even be in a position to defend whether your AI system is responsible or it's not responsible. So you have to have a defensible posture. And these practices have to be performed continuously. When there's a problem, corrective actions have to be made, the results documented, and we need to continuously demonstrate the AI system is operating within acceptable parameters and consistently producing lawful and defensible results. That's our strategy on AI. So I don't want to spend too much time on this slide because it basically just sums up what we said. One thing I do want to note here again is that, the comparison to human operators versus AI systems is an interesting one. As a hypothetical, if I were defending a client, one of the questions would be on the use of an AI system. And someone said, hey, this AI system was simply, negligent. It performed poorly. I would say, well, as compared to what? And if we look at those outputs, the results of the AI system, we compare them to, let's say, a historical data set of outputs produced by a human, and the AI system performed even better, and there was no reason to believe that the human was negligent in its performance of that same function, then I might use that as a benchmark to say our AI system met or exceeded reasonable expectations. Of course, that's a debatable position. Again, some may argue AI systems should be held to a higher standard, but we have to be out there in the law searching for how are we going to frame up AI systems? How are we going to benchmark things? And how are we going to set about to building a defensible posture? And on the flip side, if we're bringing a claim against someone, how are we going to demonstrate that their system did cause it harm and responsibility does rest with them and their system? I will note here, of course, if you're involved in any kind of litigation involving an AI system, it's going to probably be expensive because it's going to involve substantial discovery and expert witness testimony. There's no way around it, right? The systems are complex. The average person is going to be incapable of providing the types of information and sort of dissecting exactly what happened and how the system works mechanically and so forth. You're going to need experts, and those experts are in high demand right now, and they're going to charge a hefty rate, as well as lawyers who are familiar with this topic enough to be able to competently represent you. So that's it. Thank you very much. I appreciate you joining this webinar on AI risk and compliance. It's been my pleasure to present to you today. If you have any questions for me, certainly you can go to our website. Contact information for me is on there, as well as our office address is here. We're Midwest-based law firm, but we service clients globally on these unique topics. So feel free to reach out. Most of our clients are in a variety of spaces, from technology to finance. Many of them are multinational. Some are startups. Some are publicly traded. So we cross the threshold into many different industries and businesses and organizations. So please reach out if you do have questions. I'd be happy to speak with you. At this time, if anybody is still with us who has questions, we can take those now. I'm going to open it up. Hopefully, I can see if any of these questions are coming through. All right. Well, I'm not seeing anything come through the chat. So at this point, I will bid you all farewell for the day. Hope you have a great rest of your week. And I will, like I said, post this presentation up on our website and our Relic Law YouTube channel, so you can access it there. Thanks again, everyone. Take care. Bye now.